Write a short note on jurisdiction of arbitral tribunal. The provisions relating to jurisdictions are given in section 16 of the Arbitration Act. The jurisdiction of an arbitral tribunal is primarily determined by the parties' agreement to submit their disputes to arbitration. This means that the tribunal's authority to hear a case is not inherent but is granted by the parties involved. In many legal systems, including India's, the Arbitration and Conciliation Act of 1996 allows the arbitral tribunal to rule on its own jurisdiction. This is known as the competence principle. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement, and for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of contract, and a decision by the arbitral tribunal that the contract is null and void shall not enter ipso jure the invalidity of the arbitration clause. A plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitrator. A plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope its authority is raised during the arbitral proceedings. The arbitral tribunal may in either of the cases referred to in para C and D above admit a later plea if it considers the delay justified. The arbitral tribunal shall decide on plea referred to in para C and D above and where the arbitral tribunal takes a decision rejecting the plea, continuing with the arbitral proceedings and make an arbitral award. Generally, there is no appeal against the tribunal's decision on jurisdiction related to the merits of the award. Case study. In Konkan Railway Corporation Limited versus Rani Construct Private Limited, AIR 2002 SCW 426, Supreme Court has held that Section 16 enables the arbitral tribunal to rule on its own jurisdiction. Arbitral tribunal can rule on any objection with respect to the existence or validity of the arbitration agreement, and arbitral tribunal's authority under Section 16 is not confined to the width of the jurisdiction but goes also to the root of its jurisdiction.